Okay, so his attorney comes out and the attorney says to him, he says, well, we're not going to hold the pretrial today. Now remember, there hasn't even been a pleading entered in this case yet. We're not going to hold the pretrial today. They're going to hold it over until next week. So you'll come back next week and we'll hold the pretrial. So the guy goes, oh, okay. So he said goodbye to the attorney and left. Now that was on like Wednesday or Thursday of last week. The next day his attorney calls him up. It just gets better. And the attorney says to this public notary, he said, the day that they called the hearing for, I'm not going to be in town. So I'm not going to be your attorney there. We're going to have another attorney, and the other attorney is so-and-so, and they'll be there to represent you. And he goes, oh, okay. What just happened? You bet it's a switch. Why was there a switch? What did the attorney say to him? If this doesn't work, they may put a bond on me. Why would they put a bond on him? Because he just went against his oath of office. He's got evidence that the client is innocent. He put the document in his pocket and walked away. And he solicited this guy to walk away from his private settlement and go back into the public, so they could sacrifice him up and make some money. Now, since he had solicited the attorney to do the right thing, the attorney, if there's any damage, any fines, any losses that ever occur to this guy, he could come back and sue this attorney and say, if you'd have done what I told you to do, I wouldn't be in this mess. So the guy had to walk out the back door, allegedly with the permission of the client, so he would not be liable for the damages that are going to happen here. So he basically said, hey, I don't work with you no more. You're smarter than I am. And if they find you guilty, I'll lose my practice. So I'm going to give you somebody else to work with. Now, about this time, see, remember I told you I didn't have any chance to talk with any of these people about those two documents. If you want to put a comment on, please go up to the mic so that we have it on the tape. That's fine. Let's go up and put it on the tape. And our magnificent tape player manager will make sure that the appropriate dials are in the proper location so the volume gets onto the tape. If we can call him back from his private duties. There you go. We solicited him. Go ahead.
Jack, seeing that a new attorney is now going to take the case, could the notary reserve that second lawyer and start all over again?
We'll get there.
Oh, sorry.
We just keep having more fun all the time. If you're not having any fun, you're not doing it right. So, the problem was, these guys, we gave them a thermonuclear piece of paper, and they were treating it like a miniature firecracker, not having a clue what was going on. And so I called up to the people and I said, well, did you get the paper? Oh yeah, he took it into court. Well, what happened? I was laughing my head off. And I'm going, God, this guy really said this is the best description I've ever seen of this process? What is he, an idiot? It's one of those excited exclamations. Maybe they didn't have decent teachers in the law school. I don't know. They couldn't write the concept down brilliant enough for them. So anyway, I explained first to the guy that wasn't in court, his buddy, the one that was helping him, what all this was about, what it meant. And he goes, oh, that's starting to make sense. Oh, I see what you're doing now. Everybody was worried that he was going to plead guilty and go away to jail for 1,000,000 years. And oh my God. And he wasn't sure he wanted to do this, but he didn't know what else to do, so he just took it to the lawyer. And then I went through some of the other issues and showed why a negative averment, why an affidavit was necessary to raise more facts to rebut the presumption. And so he said, oh, this is cool. I'll get the public notary on the phone in a three-way and we'll see what happened. So they got him on the phone, and I spent about 2 hours just giving him the background and stuff on this. And he goes, well, he says, my wife's really upset with this acceptance stuff. It don't work. I said, okay, let me ask you a couple of questions. First of all, did you tell me or did you not tell me that your attorney said this is the best description of this process he's ever seen? Is that basically his words? Absolutely. I said, did he say that everything you gave him sucks the big one and doesn't make any sense? He said, no. I said, did he say that if you use this material, you'll surely go to jail? No. Did he say that they may actually put a bond on him if this doesn't work? Not you, but on him. Yeah. Isn't that telling you the reason your attorney bailed out is because he's already in the ringer and he doesn't know what to do? Are you telling me that this process doesn't appear to be working and is no good? By the reaction you're getting back from the attorney in this court? He said, no, looks pretty strong to me. I said, okay, let's assume we wanted to go ahead now that you got a new attorney and do this stuff all over again. And for crying out loud, don't tell the new attorney you don't understand what in the world's going on. That's a dead giveaway that they're going to try a bluff on you. I said, what is the worst thing that could happen to you under the charges if you put in this negative affidavit here that says that you're not those things? What's the worst thing that could happen to you? Isn't the worst thing that could happen to you, you'd be the first person in this court case to enter evidence, which is in your favor? Isn't that the worst thing that could happen if you do this process again? He said, yeah, I guess so, but what do you mean the first time to introduce evidence? I said, is there any other testimony affidavit in that court at all? Oh yeah, they got an affidavit in support of a warrant. I said, is it first-hand information by a damaged party? Well, no, it's by a police officer that heard this from them who heard this from them. I said, okay, so the evidence is hearsay. Under the hearsay rule, all hearsay evidence is excluded. But there is 2 or 3 exceptions to the exclusion of the hearsay. But I said, under the best evidence rule, the testimony of a law enforcement officer who heard it from Pete, who heard it from Jane, who heard it from Mary, is excluded under the best evidence rule. You have to go to Pete, Jane, and Mary to get it in, and they didn't put an affidavit in, so there is no evidence in the court. It appears as though there's affidavits, warrants, and everything else. There's no evidence. There's no material facts sworn to under penalty of perjury, true, correct, and complete, that's going to stand up in the court. Your affidavit will be the first one. Is that the worst thing that could happen to you, to get evidence in your case? He says, well, I guess so. I said, well, that's your downside liability then, and it sounds to me like it's all in your favor. Want to make a comment? Question?
Yes, this is Joe Sherry. If a lawyer ever says to you, if you go forward with this issue, whatever it is, then you will go to jail, is that blackmail, and can you prosecute them?
They're absolutely immune. They're ambassadors and officers of the court. They got complete immunity. All they're doing is testing and trying you, just like it says in Nehemiah chapter 7 we went through this weekend. Oh, by the way, I want to thank, and so does Caleb, want to thank all the people. Caleb sent out some of our Bible study tapes on Nehemiah with some of the Monday night tapes here a couple weeks ago. And there are a number of people that have provided feedback that were quite appreciative of what was going on there. Caleb took the liberty of doing that because as we are going through the book of Nehemiah, we are beginning to understand that Nehemiah was the civilian authority that was reconstituting the sovereign nation of Israel after it came out of the bankruptcy and the captivity of Babylon. And he was sanctioned or licensed by the king of Medes and Persians, Artaxerxes, to go ahead and restore the sovereignty of Jerusalem by permission of the king. And so my friend Nick Groshinen and several other people that he's been working with kind of laid on me here about a month ago that the book of Nehemiah is a coded book which tells you how to come out of your captivity when you decide to leave Babylon and how to do it procedurally and substantively. And so we're about through chapter 8 here last week. I don't know, Caleb, were you going to send out any more of those tapes?
I put on the earlier that anybody would like that.
Okay.
We would surely do that.
Very good. That was before late Smith got here, then I apologize. Late Smith. The late Smith. So, okay. But in, I believe, chapter 6 or 7, I believe it's chapter 7, we learned how the nations in captivity surrounding Nehemiah and the people rebuilding the walls of Jerusalem were charging the people of Jerusalem and Nehemiah with committing revolution against King Artaxerxes by attempting to restore the walls of their city. And it was necessary and imperative that there be some reaction from Nehemiah and the people of Jerusalem, which would be a dishonor or a confession to the charges before the surrounding neighbors could take those charges to King Artaxerxes. So what they were literally doing is they were soliciting Nehemiah to do this, do that, defend this, defend that, whatever. Not because they loved him, but because they wanted him to start acting in a manner consistent with an argument, a war, a defense, to make legitimate their false charges, so that they could take a reaction of Nehemiah and the people back to King Artaxerxes as the act or action which gave credence to the false charges. And it's a very strange chapter because as we were reading, Nehemiah 4 times dishonored some invitations of the neighboring peoples. And we're all looking at ourselves going, he's dishonoring those. But the intent, he understood that the intent of those surrounding people were to trap them into their own substantive dishonor to the king. So they just ignored him and they continued with their own business and their own defense. So there's a lot of procedure that you're seeing carefully encoded in Nehemiah to show you exactly how to come out of a captivity and do it honorably. And that's basically what we're trying to show on those tapes. Yeah, Lee?
Just a question about the procedure on the second attorney. Did the notary public hand that second attorney the letter rogatory specifically for that particular attorney?
Yeah, what we did, what I explained to this public notary, I said, if you understand this process now, and if you elect to move forward with it again as your process, I said that the second attorney is brand new starting over. Just because you offered the first attorney a letter rogatory and instructions to carry out the mission doesn't mean that the second officer named in that capacity has been given those instructions. So if you elect to proceed in the same manner, I would suggest that you rewrite the letter rogatory to the new party, word for word, but to the new party, their names in it, and give them the same instructions. And this time he came back and he said, but that first attorney said he wasn't going to do this and he couldn't do that. I said, that's exactly why you mail privately those copies to everyone else.
All right.
Okay?
All right.
So that you don't give the private documents to him to
Yes.
deal. You just give him the documents and tell him to deal in the public sector. You handle the private. If you look under the court rules, or look under the court rules, criminal or civil, all of those rules are for your public behavior in those courts. There are no rules for private behavior in those courts.
Right. That's correct.
Because you're the sovereign. And so I said, the worst thing they will do is yell and scream at you, don't you ever write the judge again. But all they're doing is they're just seeing if they can scare you off, which is what we were saying was exactly what the people surrounding Jerusalem were trying to do with Nehemiah and the people building the wall. They kept going, boo, boo, booga, booga, run, we're going to charge you, we're going to attack you, we're going to kill you. And they just go, well, okay, you know, if the Father wants you to do that, I guess He wants you to do that, but we're going to stand here and we're going to have our pitch axe in one hand in case you come, we'll go against you, and we'll have a trowel laying up the mortar in the other hand, and we'll just keep doing our job.
So he's going to send, or has sent a copy of that letter rogatory to all the people on the list of his CC list?
Yeah, this is what he's going to do. At least this is what I suggested he do. I said, first of all, when you gave it to the first attorney, you said in your letter you were going to send it to the judge and everybody.
Right.
If I were you, even though the first attorney gave you back the letter, I would go ahead and send a copy of that letter to the prosecutor,
yes,
the clerk, and the judge, just like you said you were going to do. Then what I would do is I would retype the letter rogatory with the new caption for the new agent. And you're going to send a copy of that, plus the attachments, which is the affidavit, to the prosecutor, the clerk, and the judge.
yes.
Plus, since that first attorney has been involved in your business, I would add his name to the copy list.
That's right.
And I would send him a total copy of the letter you're sending to the new attorney, just like you sent a copy to the prosecutor, the clerk, and the judge.
That first attorney is always on that case.
Absolutely.
Never,
Can't
unless
get off.
Can't get off unless
The judge
takes them off. Just
Mhm.
because he said, I'm not involved anymore, quit bothering me.
There you go.
They're always there. So that's why I wanted
Don't
to
let
go
him
through this.
assume and
Yes.
presume to tell you what's going on. He
That's
doesn't
right.
have authority to
That's
get
it.
off that case.
This is a very important part of this story.
And remember, he said they may have to put a bond on me. See, so what you're doing when you're sending out the letter that shows why he tried to desert the case, you're really putting a subtle charge on the rat jumping off the ship. But you're not charging him, accusing him of anything. You're just letting his friends know what he did. And see, the issue is, he probably told the judge and the prosecutor anyway. But you can never prove that. But if you send the letters out, and the letters are either certified mailing or certificate of mailings, and you're sending them out to 4 and 5 people, it's going to look mighty weird that he claims he didn't get them when everybody else is getting them. And if you didn't get them, why did you scuttle off the case so quick? So really, he's got to put that out. Now, he's telling that new attorney to put this, not the letter rogatory, that's private. He's telling them to put the affidavit onto the public side of the case. Now, I said, since you gave the original affidavit to the first attorney and he kept it, stole it, actually he's concealing it, you're going to have to get a new original and give to the new attorney, because an original affidavit is the only thing that's evidence. And you make copies of that affidavit and send those to the prosecutor, the judge, and the clerk. Now, they may claim you're trying to get stuff filed in the court case. And that's why you don't do it. You instruct the attorney to do it because they can file public documents. Because face it, that's a military court. And if you're not an officer of the court, you have no standing in that court. You're an enemy of the court. That's why you solicit, or actually you just accept their kind offer. And nowhere did anybody talk about money to pay for this attorney, because they won't throw into the mix the violence of law, presuming and assuming that you need to pay for the service they so kindly offered to you. Remember, you either charge for your labor or you serve by what you do. And when they offered this attorney, at no way, shape, and form did they ever say, we're going to appoint this attorney and you're going to have to pay $300 an hour. They never do that because they understand that to charge their brother would be a crime under international law. So they just say, this guy's going to serve you. And that's fine, but if you go back to Genesis 23, you don't want to get something for nothing, because if you're getting something for nothing, you're not getting anything at all. Now, what is not in this letter rogatory, and it should be, actually the one I read you was the first suggestion I gave to this guy, and when we did a subsequent one, we've added about 3 or 4 more little, you always get better. You get a lot better. So one of the things you want to suggest to them is that you want to be honorable. Please let me know exactly what it is that we need to compensate you with for your fine services for doing this, because I don't want you to suffer helping me out and assisting me in this kind matter when it's not your fault that we're here. And so please, please, please let me know how we can compensate you. Now, if he offers an invoice, you can accept it and exchange the exemption to discharge this so he gets paid in like kind, equal for equal, because you don't want to cheat him. There's no money, but he's worthy of his hire. So if he ever charges you, you want to pay him back, but you don't want to be trying to get something for nothing here. So I don't know where this is going to go yet, because the hearing isn't till the end of this week. But if this guy goes ahead and moves forward on this basis, what he's really doing is he's saying, put in the affidavit of negative averment, which shows that all I did was my job, and I don't think you can charge me as a criminal for doing my job, unless, of course, you want to come in and rebut this. Now, remember, see, when they charged him, there was absolutely no affidavit, true, correct, complete, and certain by first-hand information of the damaged party. Therefore, there is no evidence of probable cause under the common law. And if this affidavit goes into the court through that attorney, it'll be the only evidence in the case whereby he is rebutting the presumptions. And therefore, if there's no evidence against him, what has he just done to this court?
There's no controversy. They have no jurisdiction.
Well, we're not going to go with controversy, because that'll be assumptive and presumptive. Now again, now you've just destroyed your court. What did he just do in this court? He converted the court from equity to law by putting his affidavit in. What kind of court do they want? Equity. Why? Yeah, they can do whatever they want. If they're in equity, there is no facts. It's all assumptive, presumptive. So we're in Disneyland. What does the judge get to do? He gets to preside over Disneyland. He can rule Disneyland anywhere he wants. What's that called? Administrative discretion. There are no facts here. They presume this, he presumes that. They presume this, he presumes that. We're in equity. So I'll give a half a pound here and a half a pound there. We'll cut down the charge of first-degree murder to manslaughter and put him in jail. Everybody's happy. A little equity here, a little equity there. We've compromised. Everybody goes home happy. Except the guy in jail and goes, gee, well, the good news is I'm only here for half my life instead of swinging in the electric chair. Boy, I really escaped that sucker. Say, if he'd have done an affidavit of negative averment, he would have gone from equity to law. There's no evidence against him. When the case is law, what's the judge got to do? He's got to act judicially based on the facts in front of him. If he's got to act judicially under the law sets you free. Because you had nobody come against you. But if you keep that case in equity, it's all Looney Tune lands. Because you never brought in any evidence of fact. And they never had any to begin with, and they hope and pray you never bring evidence in. Why do you think the attorney put the affidavit in his pocket? Said, hey, this is really good stuff. Keep it in equity. The second it goes into the court, it's a law court, the judge has got to go judicial, and he's got to decide by the fact. How many times have you ever heard a judge give you findings of fact and conclusion of law in a court case? Why didn't he ever give you findings of fact and conclusion of law in a court case?
There were no facts.
There were no facts. It wasn't a law case. It was equity. We have any fun yet? What did Elvick tell everybody to do? You go into court and they say, oh, you're charged with running a red light, driving without a license and speeding. How do you plead? What's the first thing you say?
Full accept.
Do you have a claim against me? And they go, huh? Do you know anyone who has a claim against me? Huh? I request you release the order of the court to me right now. We're here to get your plea. Why aren't they listening to you? They don't have any claims. Where do the claims come from? Law. There is no law in their court and in their kingdom. You're saying most eloquent statements and questions. They cannot hear you in the equity court. You go, okay, I'm leaving since nobody made a claim. Sometimes they went, let them go. Now, what do we want to do about the defendant in the equity case? How about we put out a warrant for his arrest? It seems like we were just graced with the blessing of a lunatic who thought there was law here, and we couldn't hear him, but now let's get down to business. Or the judge might go, grab that man, he's in contempt of our equity court, and drag him back here. We'll throw him in jail for a couple of days and see if he'll plead to our equitable charges then. Hello? There's a reason why everything happens. You say tomato, they say tomato. It's not working in their tribunal. So what we're doing now is we're giving the ambassador directions, and we're standing outside their nation and outside their tribunal, and we're just trying to get a peace treaty drawn with this foreign court, and we're not talking about the defendant because there weren't any charges against the defendant by way of any facts that weren't true anyway. And when we do a confession and avoidance under the common law pleadings, we've completely dissolved the presumption of a substantive violation of anybody's rights here. Let them go forward with whatever they want to do. We don't care. We starting to understand what's happening? Pete?
Jump back a couple years and clarify something for me. In the case of Richard and Joan, one of the things at the end was they could not write any court officer or whatever, I don't know the exact words, but they couldn't write the judge or whatever. Amplify that a little bit for me. Is that only on the public side and they could still
Only on the public side.
They could still write
Remember,
private
weren't they creating a problem in the trial, in the public trial of the court?
Right.
So didn't the judge have to contempt him and drag him out of the public court?
Right.
So what they did is they trespassed into the equity.
Okay, so they could still write private letters to the judge or the whomevers?
Well, what would the worst thing be? The judge would say, please don't write any more letters. Okay. But you still got to communicate with your lawyer. Okay, now don't write any more letters to who? To the judge and the clerk?
I don't know exactly what the
Well, then
words
I would
were.
probably send the letter rogatory to the lawyer because he's my ambassador. And then would it be against the court order to send a copy of that letter to the county bar and the state bar? So that they know what he's supposed to be doing? Would that get you into trouble? It's on the private side. I don't know. I don't think so. See, here's the problem. Isn't it part of their system that if the prosecutor has any evidence that would exonerate the defendant, isn't it under his oath obligations to bring it forth to the court? So what you did is you gave the evidence to your attorney to file on the public side of the court, and you sent a copy of the evidence to the prosecutor. What happens if your attorney doesn't put the evidence in the court? The prosecutor comes to your attorney and says, where the hell is the evidence for your client? I'm not going to get on that bond that's going to get me in trouble too because you're not doing your job. And if that don't work, the judge will call up your lawyer and say, I want you down here in my office in 5 minutes. Just tell my secretary and walk right into chambers. What kind of a hearing is that? Private ex parte. Is there any provisions in the public rule of court proceedings for an attorney to walk into the judge's chambers on a court? In the public, he'd better not. But this ain't the public. Why isn't it the public? Because you never sent the letter to the judge on the public side. You sent the letter to the judge on the private side, and he's got a private duty to keep the lawyer that's defending the defendant in line. And if the guy is preventing the evidence from coming into the court, the judge is going to have to warn him. And if that isn't good enough, the judge will turn him over to the Bar Association for sanctioning. Do you understand why that guy says they may be putting a bond on me? Now, who's working on your side? Your lawyer? Well, if he isn't, I got 2 other guys working. They're called the prosecutor and the judge. How many more people do you want working on your side in the case? See, these patriots out there that say, I'm not going to take one of those attorneys. He's going to sell you down the river. Isn't that the dishonor that sends you down the river? How can you go into that foreign court without an ambassador and get any of the paperwork done? Caleb.
Pete took you back a couple of years. I'm going to take you back 10 years. You just answered a question.
Back to the future?
Yeah, back to the future. Now, you answered a question for me tonight that's been, for years and years. Remember when we used to argue the thing about the pro se? We're not pro se, and we'd spend, 4 reams of paper to telling them why we are not and why we're not. And they would go ahead and just put on the journal entries and everything, just pro se, put your name in pro se, just go on like it was nothing. Well, it's exactly what you just said tonight is that we were trying to be on the private side, and that's an equity court, and they can only have their chancellors in there. And so they just make you an honorary one for that particular time. And
so look what happens. Because you won't do it right, they bring you in there as an officer of the court. Now are you a public part of their community? There's your jurisdiction. If you would have just written your letter rogatories to the attorney they wouldn't have had personam over the living person. Because you were going in there through your agent. What sovereign goes and first-hand negotiates any peace treaty? You ever seen President Bush go out and negotiate a peace treaty that wasn't already set up by his Secretary of State? So why are you running into their court negotiating a peace treaty in their court? Scripture says don't go into their court because you become one of them by going into your court. If you go in through an ambassador, then you've maintained your sovereignty. Yeah, Lee.
As a understanding of the process of letter rogatory to the attorney, I believe we have been talking about putting together a contract for the attorney so that they become your lawyer. This is that process.
Yeah, but if you're putting together a formal contract and you're going to try to get them to sign it, good luck. You'll never do it.
This is the process.
You do it. You don't ask him to sign a writing. You actually do the process by directing him.
That's right.
And you send out the copies to your witnesses so everybody knows you told them.
And there's consideration given in the letter rogatory on Jack's second time around.
By offering to pay.
Remember the consideration that makes a contractual agreement.
Absolutely. See, we can get better all the time.
Yes.
In fact, when I came back that second time, I added a couple of other things. Let me see if I can find those so I can tell you what I put in there. We got down toward the end. In 7, I request all of the charging instruments in this matter affecting the undersigned be accepted by you under your signature for and in behalf. If my signature is required, let me know. If this court fails to issue an appearance bond to the undersigned under the requested terms of the paragraph 3, I request that you notify the court publicly of my acceptance of the court's dishonor, and I will presume, based upon that dishonor, that the appearance bond is in fact issued to the undersigned to secure the undersigned's participation in this matter. We're not going to argue with these people if they didn't do it. But since you're presuming it now, what have you just done? Gone back to equity. You've got to rebut the presumption with a fact. Okay? Now, how do you rebut the presumption with a fact? Well, we have some people, and next week I'll talk about this, that are putting bonds in the court. And I've got samples of a page here. You start off with your name, address, city, state, and zip at the top, name of the court, in bold, and the caption, the plaintiff versus defendant, and then on the right-hand side you say bond and the case number. Here's what it says in the document. There appearing no bond of record to initiate the matter regarding case number such and such and associated accounts, then your upper and lower case name of offender, because this bond is for you, not the defendant. Undertake as follows. What we're doing is writing a letter of undertaking. In consideration thereof that no lawful money of account exists in circulation, and in consideration thereof that I, the undersigned, have accepted all offers in the herein case number for value and returned all offers for value and requested settlement and closure of all charges, fines, fees, costs, and restitution, if any, and have also accepted for value any and all dishonors regarding the matter of case number such and such and associated accounts, I, the undersigned, do hereby underwrite with my private exemption Social Security number, the SSN without dashes, any and all obligations of performance, lost costs, sustained by the United States of America / state of whatever, and the respectful citizens thereof regarding said matter, done at your county, your state, this day, whatever, and then you sign your name, and you can do a certificate of service, and you put this bond into the clerk of the court and the original you ask her to file and stamp you your copy. What have you just done? You put a bond in fact in the court. Now, this is something that you need to do because as the principal, you are the undertaker. Isn't the undertaker the one that deals with the dead? And if you won't give up your life and die, you can't save your life. You've got to underwrite all the liabilities in that matter in order to come out on top. So now, no longer, if they refuse to issue you the bond, you go in fact, and do it because based on their dishonor, you have the capacity to do it notwithstanding. This is the bond for the offender, not for the defendant. Number 9, attached here too is an affidavit of negative averment. Maybe I didn't fill out all of these things, but now what we're going to do is we're going to add the payment, quote unquote, offer to the attorney as consideration for his services. Because that completes the deal because you're not asking for something for nothing. Okay, so it just keeps getting better and better. We're going to go ahead and do that. Now, next week, because our time is up, next week I'm going to talk to you about what's going on in terms of bonds and in terms of controlling these courts so that literally we make law courts out of these equity courts so that the judge is placed in the position of having to rule on the facts so that you must understand how it is that you turn the judge in the court into a law proceeding instead of an equity proceeding. Because everything we've been doing so far, we've been bringing our contracts and our facts into equity courts. We have never converted them into a law court. The equity judge cannot hear or see our contracts and can't hear and see our certificate of protest. So he totally ignores them and comes up with an equitable order that goes completely against the agreement of the parties and the evidence that you're trying to submit. You cannot submit law evidence into an equity court. And so next week we'll talk about how you convert the equity court into a law court to get your remedy. If people came in late and didn't get copies of the matrix transcript, we still have some of those up here. Okay, God bless you. Hope we all get back in a week and we'll go from there.